Hi, very good morning. This is a Supreme Court judgment under FEMA. Citation is J. Srinisha versus Special Director. Facts of the case: it was alleged that a director of a company acquired 70 lakh shares of a Singapore based company without consideration and without prior approval from RBI. Without approval from RBI. Why prior approval? Without approval from RBI. Subsequently, the director transferred the same to his wife and children, those shares. That was the allegation. So the authorized officer, he applied to the competent authority for resorting to procedure under section 37A of FEMA, Foreign Exchange Management Act. Section 37A permits seizure of properties within India. But the competent authority, that is the higher authority, to the authorized officer, he came to the conclusion that there was no proof that money was ever paid for the shares of the Singapore company. Hence, on that basis, he held that there was no contravention of Section 4 of FEMA. So, Section 4, it prohibits a person resident in India to acquire, hold, own, possess, or transfer any foreign exchange, foreign security, or any immovable property situated outside India without permission of RBI. So there is a clear restriction. The proposed seizure was rejected by the competent authority because, according to him, there was no money consideration paid outside India. This order of the competent authority was challenged before the appellate tribunal and the same was pending. This is one part. The other part is, in the meantime, the authorized officer, he parallelly moved the adjudicating authority under section 16. The adjudicating authority issued a show cause notice. This show cause notice was challenged first before the single bench of Madras High Court and then before the division bench of the Madras High Court. The challenge was on the ground that once the competent authority recorded categorical finding that there is no basis for seizure of the properties, there was no tangible material to conclude that the director and his family violated the section 4 of FEMA. Hence, show cause notice, according to them, was non-est in the eyes of law. That is why they filed a writ petition before the single bench. Single bench dismissed the writ petition. Division bench also dismissed the writ petition against the show cause notice, saying that show cause notice against the, writ petition against the show cause notice is not entertainable. Hence, SLP was filed before the Supreme Court, challenging the order of the division bench. Supreme Court looked into section 37 of FEMA, 37A of FEMA. Supreme Court said that it is enacted to ensure that the asset of person involved in foreign exchange violations may be seized to the extent equivalent to such foreign exchange, which may be under the scrutiny of the adjudicating authority. So if you have violated 100 rupees foreign exchange in Singapore, 100 rupees worth of property can be seized here in India. It is in the nature of a preventive measure for ensuring that assets equivalent to foreign exchange may be kept secured for future proceedings pursuant to adjudication. That is the purpose and object of section 37A. Section 37(4) gives the impression that order passed by competent authority confirming the seizure would remain alive only till disposal of adjudication proceedings. That is the seizure order. If it is confirmed by the competent authority, it will remain in force till the disposal of adjudication proceedings. And the adjudicating authority, he would be authorized to proceed with the further actions. The effect of such order is to leave the assets at the disposal of the adjudicating authority for realization of the adjudicating amount. adjudicated amount, if any, to prevent frustration of the adjudication order. Suppose if the order is passed and no asset is seized, then it will remain a mere paper, useless. You cannot enforce it against the person. He may escape, he may run away. So that is why the assets in India are seized. So that once the adjudication order is completed, the assets can be released and the money can be recovered. This provision is restricted to an order of competent authority confirming seizure of equivalent assets till disposal of adjudication proceedings. But the provision is silent with a situation where seizure has not been confirmed by the competent authority. In that case, what happens? The provision is silent on that. Section 37A1 predicates that the power of seizure is predicated upon existence of reason to believe that foreign exchange or immovable property situated outside India is suspected to have been held in contravention of Section 4. Already we have seen what is Section 4. Such a satisfaction by authorized officer at preliminary stage is only tentative and is subject to scrutiny by competent authority. Competent authority is required to independently examine whether the reasons recorded justify continuation of seizure. This exercise is not an empty formality but a substantive evaluation of whether the material on record is sufficient to sustain a prima facie inference of contravention of Section 4. So that is not a mere formality. He has to apply his mind and then decide. In the present case, the competent authority, upon such evaluation, he declined to confirm the seizure by well-reasoned order. Hence, the foundational requirement of reason to believe it was not satisfied in this case. That is point number 1. Then the Supreme Court took up the next issue. Because Madras High Court said writ petition is not entertainable against the show cause notice. On that ground, it dismissed. Supreme Court deferred with the view of the High Court that writ petition against show cause notice is not entertainable. Supreme Court said that it is not applicable in all situations. So the High Court is supposed to look into the situation. Supreme Court said that 1. When there is patent lack of jurisdiction. 2. When there is non-application of mind by the authority. 3. When the issue is predetermined or the issue is approached with a premeditated mind. 4. When there is abuse of process of law. And 5. When there is violation of principles of natural justice. In these situations, the writ petition is entertainable. Now, the other issue which Supreme Court looked into was interim seizure under Section 37A and the adjudication order under Section 60. The division bench of Madras High Court, while deciding the issue, held that interim seizure made under Section 37A may not have any implication in respect of final order to be passed by the adjudicating authority under Section 16. In this connection, Supreme Court, after noting the observation of division bench, Supreme Court held that the observations of division bench impliedly efface the findings recorded by the competent authority. This will foreclose the outcome of appeal pending before the appellate tribunal. Already we have seen that. Because first the authorized officer wanted to seize the property. It applied for permission to the competent authority. Competent authority refused. Then they filed an appeal before the appellate tribunal. The observations of the division bench will foreclose the outcome of the appellate tribunal. Because once the division bench has held something, the appellate tribunal cannot go against it. Based on observations of division bench, the adjudicating authority has undone the order of the competent authority while the appeal against the order is pending. This will tantamount to abdicating the powers of the appellate authority even when the order of the competent authority was under challenge. Yet Supreme Court set aside the order of the division bench. Supreme Court directed the appellate tribunal to decide the appeal against the order of the competent authority without having any reference to the observations of the Supreme Court also. After disposing the appeal, the proceedings by way of issue of show cause notice and other things can be commenced. If the appellate tribunal concludes there is no material, there is no tangible evidence, there is no violation of foreign exchange, then, or if it confirms the order of the competent authority, show cause notice will not be issued. Suppose if it takes a different view, then the proceedings by way of show cause notice can commence. So that is the judgment of Supreme Court, very interesting. And my simple comment is, nowadays what I am observing is, I am sorry to say this, in high court generally speaks more and hears less from the advocates. Whereas it should be the other way around. It should hear more and talk less. The High Court should speak through its orders only. Uh, because the moment the High Court judge takes it, no, 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 it is not entertainable, finish. Sometimes the judges are very, I can't say in so many words, very aggressive. So no advocate, if he's a soft type, he will not try to judge rub the judge and spoil his other cases. So he will take it. I think, in my view, only senior advocates, they are hearing well. But when advocates are not senior advocates, then the aggression is very much, which I am perceptibly seeing in high courts, especially in the case of advocates who are directly promoted as judges. I don't know whether there is an internal rule or something or internal training that happens. I'm not very sure about this. In my experience and what I have seen in the courts, I am sharing. Uh, otherwise, many cases may not go to Supreme Court. Is my personal humble submission. Each advocate should be allotted a given time, or they can ask how much time you want. Within a few minutes, you should tell the facts. What don't talk too much. Don't repeat the arguments. Tell the facts. What are the points, and then what is your submission? Within 10 minutes, you say, or 15 minutes, or they can ask for written submission. If the people are giving 300 pages, artificial intelligence is there. You just put the PDF in artificial intelligence. It gives a brief of what is the case. The judges can read that. Synopsis, what is the use of giving synopsis? I'm just expressing all these things. I can't say more. Thank you very much. Have a great day.